Tom Maddrey here, ASMP's General Counsel and Head of National Content and Education. And I am super excited to introduce you to the first episode of our new show, Focus on the Law. This is a place where I get to geek out a little bit on all the legal things that are going on in the world related to visual content creators, with a particular emphasis on copyright, right? That is my most favored area of law, the topic that so many of our members ask us questions about. And so I want to give a little bit of an overview to what will be going on during these episodes and in this show. So in every Focus on the Law episode, there's going to be at least 3 segments. The first segment, we're going to talk about a case. And this is a case that I want to do a little bit of a deeper dive into. Some of the cases you've heard about and you've seen us write about at asmp.org. Other cases you may have never heard about, or this is the first time you're learning about them. And the cases can run the gamut. They're not just going to always be copyright cases. Sometimes they'll be contract cases. Sometimes they'll be rights of publicity or right of privacy cases. And there's going to be a whole bunch of others put there into the mix. So that's segment 1 of these Focus on the Law episodes. Segment 2 is a little dive into some of the things that are going on in the news that might be of interest and bridge the gap between the legal world and the content creation world. Here we're going to look at hashtag consent, for example, which is what we're going to talk about today. That practice that if you put something online and you give it a certain hashtag, then you're consenting to have that brand use your image in a commercial way. We're going to take a look at what we think about the legality of that and what do we think about the policy of that. And then the third part of every Focus on the Law are going to be quick hit legal FAQs, right? We're just going to take about 5 questions each episode, answer those, put them into the legal FAQ archive right there on the Academy site. And we're going to see a huge library of questions grow. There will be more questions on the website than we'll have time to answer in these Focus on the Law sessions. So for now, sit back, relax, and let's get started by looking at a case that many ASMP members are familiar with, a case that an ASMP member is at the center of, and that is the Andy Warhol Foundation versus Lynn Goldsmith. That's where we're going to start today. So in Warhol versus Goldsmith, we're asking a question, right? And the question we're asking is, what is the process, what is the procedure, what is the right thing to do when you have a photographer who created an iconic image, and then that image is licensed and used by a very famous painter for an illustration. And unbeknownst to the photographer, different copies and different versions are made. And then many years later, those copies and versions are being sold. Is that okay? Is that okay? So the easiest way to start looking at this case, and we're going to get into the background and the details here, but let's take a look at the image itself and what kind of question we're talking about. So in the image on the left, we see Lynn Goldsmith, famed rock and roll photographer, who took this image of the musical artist Prince shortly before his Purple Rain tour, the tour that launched Prince to be a household name. And that image was then used as an artist reference, which appeared in a magazine, and the artist was Andy Warhol, and Andy Warhol created the image on the right. Now, this was one of a number of images that Warhol created that was using Lynn's image. Before I get into the background, let me give a few disclaimers like lawyers always do. So in this case in particular, I have written multiple briefs to the court on how their rulings will affect all visual creators and photographers, especially in relation to copyright issues. And I've written these briefs on behalf of Lynn Goldsmith. That's one of the things that membership in ASMP allows us to do, which is go to the courts and advocate on behalf of photographers in situations just like this. Now, those briefs, which you can find linked on the resources sidebar next to this video, those briefs are incredibly enjoyable to write because you really get to dig into the case and see how the different rulings would affect photographers who are actually doing this stuff in the real world, right? And hopefully we're able to persuade the court on certain issues that we find most important. Now, as I mentioned, Lynn Goldsmith is an ASMP member, and so we have certainly been supportive of Lynn all the way through. Now, that isn't to say that we don't find that Andy Warhol is an iconic American artist who has done amazing works and done great things. But as we get into the details here, I hope you can see why the position that Lynn is taking is different than the position that the Andy Warhol Foundation is taking. And you can kind of draw your own conclusions as to which position is better suited. Let me give you a little bit of background on the case. So in 1984, Vanity Fair magazine contacted Lynn to license an image of Prince for an upcoming illustration in a magazine, in their magazine. And they licensed it as an artist reference. Now, totally cool. Everyone's happy up to this point. The image that was taken by Lynn was properly licensed. The scope of the usage was clear. It was to be used as an artist reference for an illustration by a then unknown to Lynn artist for use in Vanity Fair magazine. And the concern is that not only was it used for the illustration in the magazine, but Warhol went on to create 16 works in total, which were dubbed the Prince series, all based on this original photograph of Lynn. So when Prince then died in 2016, Condé Nast, who owns Vanity Fair, reached out, not to Lynn, but reached out to the Andy Warhol Foundation, and they were seeking to license one of the Prince series for their magazine where they were talking about the death of Prince. Now, when Lynn saw this, she went to the Andy Warhol Foundation. She said, hey, a few things. One, I didn't know that all these other things were created, but two, no one licensed it from me. You know, back when you originally licensed it in 1984, you went through the proper procedures. We had a license agreement, and you gave me credit in the magazine, you know, artist reference and image courtesy of Lynn Goldsmith. And that's the way to do it. And here, you just kind of license this work to Condé Nast, and you didn't include me, right? And that's not okay. So in response to that, the Andy Warhol Foundation then did something in the law we call a deck action. And that's where they went to the court and they sued Lynn Goldsmith. And they said, court, we want you to declare, we want you to determine that Lynn Goldsmith does not own the copyrights to the images that Warhol created. And if she does, then it's a fair use under fair use law. Now, you can learn a lot more about fair use law in the upcoming Advanced Copyright Topics course at the ASMP Academy, where we dive into each and every detail. But for the purposes of today, I just want to go over some of the basics of fair use. There are 4 factors that we look at and courts look at when evaluating if something is a fair use of a copyrighted work. And these 4 factors, none of them are what they call dispositive, which means that it's not like if we say yes on factor 1, then we can just stop the analysis and not look at it. We have to look at all the factors as a whole. And in this case, because this matter turned on whether the use by the Andy Warhol Foundation was fair use, the court, both at the district court level, which is the first level, and the appellate court level, which is the intermediate level, examined this case and looked at the 4 fair use factors. So in the district court, at the very first court case, the court found that this was fair use, that the Andy Warhol Foundation was able to do this, and they were able to do this without contacting Lynn and without licensing the work. Lynn appealed, and it went to the appellate court. Now, the appellate courts, you might often hear about the Second Circuit Court of Appeals or the Fifth Circuit or the Ninth Circuit Court of Appeals. And what that's referring to are the intermediate courts, the step right below the U.S. Supreme Court. And the circuits encompass different states. And so, you have the Fifth Circuit down here where I am in Texas, and it covers Texas and Louisiana and a few other states. But the circuit where this was brought was in the Second Circuit, which covers the state of New York, among others. And the reason that this is so important is because the Second Circuit is where so much law in copyright has been created, and even further, so much law in fair use has been created. There's a very famous case that we're going to look at in a future Focus on the Law episode, and that's the case of Carew versus Prince. This is an amazing case that talks about another artist, Richard Prince, who used the work of photographer Patrick Carew, and we're going to take a dive into 1, was it legal, and 2, was it ethical, right? Sometimes we're going to step just slightly outside of the legal boundaries here on these shows. So Lynn lost at the district court level, that first level. And so she appealed to the Second Circuit Court of Appeals. And in September of 2020, the court heard oral arguments on this case. And what oral arguments are where the lawyers for each side will give a very short presentation, kind of an argument to the court, and then the judges on the Court of Appeals will ask questions to the lawyers. And that's the only time that there's a verbal exchange between the judges and the lawyers when you're at the appellate level. And the real meat of an appeal comes from the brief. And so when we talk about a brief, we're talking about something that's 30 to 50 pages and goes over all the law and all the reasons why the judges should find in one party's favor or another party's favor. And so I listened to the oral arguments back in September of 2020, and I wasn't entirely sure how all this was going to go. But there were some questions from the judges that made it real clear that they weren't totally on board with what the Andy Warhol Foundation was saying. Now, it's always a bit of a dicey proposition to base what you think might happen in the case off of the questions that the judges ask in oral argument. But what ultimately turned out to be the case was that the Second Circuit Court of Appeals came back and they found that not only was the lower court wrong, but all 4 fair use factors favored Lynn Goldsmith. And so they reversed and remanded the case so that the lower court could again evaluate it with these new rules in mind and this new interpretation in mind. The Second Circuit Court of Appeals, held a few things. And I'll give you some quotes here from the opinion that I think are particularly relevant. The first quote I'm going to give you from the opinion is about the fourth factor. And the fourth factor is one of the four fair use factors, and it discusses the harm to the market if the use, the alleged infringing use, were a widespread use. And so the best way to think about it is, if someone uses my photograph and they are in the same market that I'm in, then their use is depriving me of that part of the market, and it's harming me, right? And so if it's found that there is market harm, it's less likely to be found a fair use. Remember, not any one factor is dispositive. You have to look at them all together, so this just weighs in favor of one side or another. So the court held, quote, "The question under the fourth factor is not solely whether the secondary work harms an existing market for the specific work alleged to have been infringed. Rather, we must also consider whether unrestricted and widespread conduct of the sort engaged in by the Andy Warhol Foundation would result in a substantially adverse impact on the potential market for the Goldsmith photograph." And this was great, right? So from the point of view of content creators and photographers. And the reason this was great is that the court was saying, look, even though you might have some arguments that the market for Andy Warhol paintings and Lynn Goldsmith's photographs are very distinct, you have to think about a couple things. One, in this case, the market was the same. And what I mean by that is there was a publication that was looking for an illustration to accompany a written article about an individual. And they could have chosen Lynn Goldsmith's Prince photograph, they could have chosen Andy Warhol's illustration, they could have chosen one of the hundreds or thousands of other works that depicted the artist Prince. And so in that sense, they were very much in the same market. They are directly head to head. But the second part, and the part that this quote goes to, is that it's not about just what are the existing markets for the work, but what are the future markets for the work? What are the potential markets for the work? Because one of the rights that you have when you're a copyright owner is to determine where and how your work is disseminated and what markets you want to be in, right? And so the court here is saying we have to look at both the current existing market and the future potential markets. And that was a really important holding. Now, they also talked about the first factor. And when you talk about fair use law, you talk about the first factor almost more than any other factor. And the first factor has a couple pieces to it, but one of the most important pieces is this idea of transformation. Because if you transform the underlying copyrighted work, it's more likely to be found of fair use. And what does transform mean? Well, there was this very famous case back, I think now 26, 27 years ago at the US Supreme Court. And it was called Campbell versus Acuff Rose. We'll put a link to it over in the sidebar. And in Campbell versus Acuff Rose, we talked about, the court talked about transformation. They talked about a different message or new meaning that was brought to the work from the original. And there's a couple other things that go into transformation, but I want you to kind of remember message and meaning because that's what's often associated with transformative use of the works. Now remember, transformation is just one part of that first factor. So with respect to the first factor and that idea of transformativeness, the court said, quote, "The secondary work itself must reasonably be perceived as embodying an entirely distinct artistic purpose, one that conveys a new meaning or message entirely separate from its source material. So this was a pretty big holding, right? Because the court here was doing some gymnastics around some of the previous cases that it had examined, including the Carew versus Prince case. But let's dice up a little what it's saying. The secondary work, meaning the work that Warhol created, must reasonably be perceived as embodying an entirely distinct artistic purpose, one that conveys a new meaning or message entirely separate from its source material. So that's a lot, right? That's a lot for a couple reasons, and it's a pretty broad holding. It seems to be saying that if the secondary work, the work that's using the underlying source material, can't reasonably be perceived as being an entirely distinct artistic purpose or conveying an entirely new message or meaning than the source material, then the first factor is going to weigh towards the copyright owner, the underlying image, in this case, Lynn Goldsmith. Big holding, big quote there, right? And something that I think it's important to note in this case. Now, at the end of the day, the Second Circuit Court of Appeals reversed the lower court and held that all 4 of the fair use factors favored Lynn Goldsmith. So we're done, right? Lynn wins. We're good. Fair use. The Warhol Foundation can't do this in the way they did that. They could have come back to Lynn. They could have licensed the work in the way that they did back in 1984. That wouldn't have been much of an issue here. There certainly wouldn't have been a lawsuit. But after this, shortly after this, there was a case that was heard at the U.S. Supreme Court, one level above the Second Circuit Court of Appeals. And this case had nothing to do with photography or music or art or anything. This case had to do with software code. And it was a very big case. And the reason it was a big case is it was the first case since Campbell versus Acuff Rose that I mentioned earlier, that the Supreme Court was evaluating fair use. Okay? In this case, it was called Google versus Oracle. Again, we'll put a link to it off to the right. And so the Second Circuit ruling came out, and then the Supreme Court released their opinion on Google v. Oracle. And in this case, Oracle sued Google for copyright infringement because Google copied code that Oracle had, software code that Oracle owned, and used it in their APIs. Google said, hey, this type of code is fair use. Now, we're not going to dive into this opinion, but the upshot is that the Supreme Court agreed with Google and found that it was fair use. Immediately after that, the lawyers for the Andy Warhol Foundation came back and they filed a motion with the Second Circuit Court of Appeals for rehearing and reconsideration. And it's called en banc, which is all the judges. And the reason that they did that was based on the Google opinion that had just come out of the U.S. Supreme Court. They said, hey, Second Circuit Court of Appeals, we now have some new rules that the U.S. Supreme Court just gave us in Google v. Oracle. And so when they filed that motion, the Second Circuit Court of Appeals granted the motion to rehear this matter, the Warhol versus Goldsmith matter, in light of the new ruling in Google v. Oracle. But at the end of the day, what they found, and there were no oral arguments, this was just on briefing, right? What they found and what they said is that, quote, we emphatically reject the Andy Warhol's Foundation assertion that Google comprehensively refutes the panel's reasoning. And they reaffirmed that even in light of Google v. Oracle, which just came out of the U.S. Supreme Court, Lynn Goldsmith prevailed on all 4 fair use factors, that the Second Circuit's analysis was unchanged by the new circumstance. A second huge win for Lynn Goldsmith. So that kind of brings us up to present day. There's a few things that can happen at this point. One, there's always the right within a certain prescribed period of time for there to be various appeals to the U.S. Supreme Court or others based on new information, things like that. Often what will happen at this point in the process is the parties will come together based on these new rulings and figure out some kind of agreement to end the case. The case has been remanded down to the lower court. So all these things could happen in this case, and you can certainly stay up to date on the latest news in Warhol v. Goldsmith over at asmp.org and the ASMP Academy. So I hope you found that interesting. There's a lot of facets to that case. We've written a lot of articles on it and put a lot of links over in the sidebar to the right. And certainly, if you have any questions or thoughts, you can always email us at academy@asmp.org. Definitely love to hear from you. I want to move on to something that's been in the news recently. And it's not brand new, but it just came up again, and I think it's worth talking about. So let's turn to that now. Recently, our friends over at Petapixel published an article called Delta Uses Hashtag for a Photo Rights Grab. And this article is talking about something that was tucked into Delta's terms and conditions of their SkyMiles program that people had to agree to when they joined the program. But it's not the first time that we've seen this idea of what is called hashtag consent. The bottom line here is that what companies have said in certain documents, like the ones we're going to look at, is that if you publish an image on social media and you use a certain hashtag, then by publishing that image and using that hashtag, you are consenting for the company to use the image in the ways that were outlined. Now, you can imagine that photographers find this very concerning, and certainly ASMP finds it very concerning. This isn't a new practice, however. The first instance of this, including with Delta, goes all the way back to 2015. And while there have been some articles about this, and some courts have kind of looked tangentially at this, there isn't any hard and fast rule about how we should approach this. Let's take a closer look at what Delta has said. So as part of the SkyMiles program at Delta, there's part of their terms and conditions that says, by tagging photos using SkyMiles Life and or Delta Medallion Life, user grants Delta Airlines and those they authorize a royalty-free, worldwide, perpetual, non-exclusive license to publicly display, distribute, reproduce, and create derivative works. Wow, that's very expansive, isn't it? That's like all the things, right? That's all the rights. And so what they're saying is, if you post something, if you're a SkyMiles member and you post something and you use hashtag SkyMiles Life, then just by using that hashtag, you have now granted to Delta this kind of usage of your image. I don't think you can do that. Now, what I think might not carry a whole lot of weight, but I think that this is something that we've seen not only with Delta, but with some other companies. Earlier, or at the end of last year, the Museum of Modern Art did something very similar, where if you were in the museum's MoMA Photo Club and you used that hashtag, then you had a chance to be chosen for the museum's use on social media, their website, and on digital screens in New York City subways. Which sounds great, right? For photographers who don't make their living as photographers, because this is exactly what we would want the Museum of Modern Art to hire photographers to do, professionals. The fine print that was at the end of this MoMA Photo Club said that photographers are granting the museum a broad license to use, display, distribute, create derivative works of the photograph now and in the future for any purpose. So these are very broad rights grabs. These are things that are very concerning. And the question really comes down to, one, can a company force you as part of its terms and conditions to agree to this? Two, if you do agree to this and you use that hashtag inadvertently, have you now entered into a license agreement? And three, what if you're not part of this program and you use that hashtag? So in the law, generally, you are held to the contracts that you enter. Very few people, myself included, read all of the terms and conditions on all of the things that we're presented with. And this was literally 5 lines inside of a much longer document, and that is often the case. So the first thing to consider is it legal for companies like Delta to even include this language? And the general answer is that yes, it's legal to include it, and if you sign off on it, then you're kind of acceding that what was written in there you agree to. But it goes a little bit deeper, because this type of copyright transfer agreement is one that in copyright law, if you transfer your copyright over, that has to be in writing and it has to be signed. And there's a lot of argument about, is this a proper writing and is it signed in this certain way? Because the main issue is that it's not just that you're granting them the right to use it on their social media. These are incredibly broad rights. You're granting them perpetual, unlimited, rights for them to use it in any media and in any way that they want to, now or in the future. That is something where you're essentially giving all of your rights. You're giving all of the rights associated with your work to someone else. When you do enter into those types of agreements, it starts raising other legal issues, like, have you now actually transferred your copyright? That's a harder hill to climb because of the non-exclusive piece. But I want to step back a second and look at this from the perspective of the ad agency who's working for these companies and for the photographer who may not be part of these companies. And so a good example is back a number of years ago, a woman posted a picture to Instagram of her young daughter in a pair of Crocs sandals, tagging it #Crocs. Crocs used the photo and posted it to the company's Instagram profile. And then after posting the photo, Crocs requested permission to use it and asked her to respond #CrocsOK for consent, and she declined to do so. And so now we have a situation that we've actually seen more than once come up, which is photographers on social media are asked to just agree by using a hashtag or something else to license a specific image, and they declined to do so. In this case, Crocs had already used the image, so there's certainly some issues there. Additionally, Calvin Klein hosted ad campaigns asking aspiring models to hashtag their photos My Calvins for a chance to be featured in their gallery. Look, different evaluations of this have come to different conclusions. There are certainly a camp of people who believe that by using a hashtag that's identified in this way, it's granting an implied license, implied consent to use the image on that company's account. I absolutely disagree with that, right? I don't think hashtag consent is legal, nor do I think it should be legal. Because essentially you're forming a license that you may not even realize you're forming at the time you're forming it. And an underlying concept in all license agreements, and remember, a license agreement is just a type of contract, is that there is a meeting of the minds on what the terms of the contract are. And so if you happen to hashtag your work with one of these certain hashtags and you walk down the street and you see your picture on a billboard, would you believe that you had implied that you had given your consent for that image to be used in that way? I think the vast majority of people, whether they're professional photographers or not, would say no. And this seems like a legal backdoor that's very concerning. So ASMP is always on the lookout for these situations and will write letters and do things to try to get in there and convince these companies that, one, this isn't a practice that should exist, and two, you really have to constrain your rights. You know, you just have lawyers out there for these companies who want all the rights that they can possibly have accrue to their clients. That's something that obviously professionals fight back against, but the vast majority of images that are on Instagram are not taken by professionals. The problem is that those images are then used in commercial and advertising work in a way that supplants and harms the market for professional photographers, and that's something that ASMP is, of course, strongly against. Now, as I mentioned, this is not a new phenomenon. We've been dealing with hashtag consent issues since 2015 at least, and we're going to continue to deal with them in the future. We will keep an eye on any cases that come out that are discussing these issues and give you updates and see what we can do to help prevent this from happening. So that's just a little survey of one topic that made news in the last week. Of course, if you want to find out more about what's going on week to week, you can check out ASMP's Week in Review. That launches here at the end of October 2021. And so with that, we're going to move on to the next part of this Focus on the Law episode. And we're going to answer some legal quick hit FAQs. And look, we're going to be starting, this is episode 1, we're going to be starting right at the beginning with some very straightforward questions. As we continue these episodes through the months and the years, we're going to get into much more complex topics and issues. But why don't we start at the start? And that's what we're going to do right now. How do I get a copyright in my work? So you hear us talk about copyright all the time. And when we look at what is required to have a valid copyright, here's what the Copyright Office and the copyright law says. To get a copyright in a work, it has to be an original work of authorship by a human that's fixed in a tangible form of expression. It also has to have a minimal amount of originality, right? And when we say minimal, we mean minimal. So it's pretty much like not just facts, okay? Just facts are not copyrightable, but almost every photograph you take, every video you take, every document you write, anything that is an original work of authorship that possesses minimal creativity, done by a human author, that is fixed in a tangible form of expression, the minute you create that work, you own the copyright in that work. You don't have to do anything. You don't have to tell anyone. You own the copyright at the moment of creation. For photographers, we talk about when you press that shutter, you now own a copyright in that work because the image is in a tangible form on your sensor. But something we often get asked, well, what's that whole deal about tangible? What that means is that you can't copyright an idea. It has to be in a tangible form. So let's say you have some choreography that you want to copyright. It's perfectly copyrightable, but it has to be on film, or you have to have written out the dance steps on paper. You can't have just people performing the choreography and it's not done in a tangible way. It's not recorded in a tangible medium. That tangible medium part's important. How do you get a copyrighted work? You just create a work that is fixed in tangible medium and it's original and has minimal creativity, and you are good to go. You own that copyright from the minute of creation. How long does a copyright last? Well, of course, I'm talking about US copyright law here. And in the US, the current term of copyright is the life of the creator plus 70 years. The life of the creator plus 70 years. Now, there is one twist to that, and that is if the copyright is owned by a company, and there are a couple ways that can happen, mainly through kind of a work for hire agreement. If the copyright is owned by a company, then it's either 95 or 120 years. Which one is it? Well, it has to do with whether the work is published or unpublished and the year of first publication. All of that we go into in some of our other copyright classes. But what is the term of copyright? The way to think about it is that for an individual, the term of copyright is your life plus 70 years. Copyright's an asset, you can put in your will, anything like that. Does a contract have to be written and signed to be valid? Well, if you've taken our course on contracts over in the Path to the Profession curriculum, you'll know that a contract has three parts: offer, acceptance, and consideration. And actually, all you have to have a valid contract are those three things, which means any agreement that you make over the phone, in person, via text, via email, in some 50-page written agreement signed by everyone, those are all valid contracts. But if you have a contract that's only spoken, doesn't have any evidence, written evidence as a component of it, it's a lot harder to prove if the other side says, you know what, I don't think that's what we agreed on. So it's always good to have a written contract, but you got to think of contracts on a continuum, the most provable to the least provable. And it goes from just talking to a buddy to texting, and emails are better than text, and written agreements are better than emails. But all of those things constitute a contract if you have offer, acceptance, and consideration. What is an LLC? So there are four basic types of companies out there in the world. One is a sole proprietorship. This is where you and your company are indistinguishable. Another is a partnership, which is also kind of a sole proprietorship, except there's two or more people, which means in a general partnership, you and your partners are both 100% liable for what goes on in the partnership. There's the corporation, something we're all familiar with. A lot of the world's biggest companies are corporations. All these forms have different formalities. They all require different things. But the business form that I think is most successful for individuals and small groups of creators is the LLC. LLC stands for Limited Liability Company. And unlike a sole proprietorship, in an LLC, you are only liable to the extent of the assets in your business. So if something terrible were to happen and you were to be sued, if you're a sole proprietor, you personally get sued. You could lose your assets, in some states your house and your money. But with an LLC, if something terrible were to happen, you are insulated from your business by that limited liability of the LLC. So LLCs are a wonderful business form. You can learn a lot more about them in the other courses here at the Academy. But an LLC stands for Limited Liability Company. What is the number one thing to look for in a lawyer? Well, I want you to have a lawyer as part of your team. You should have an accountant and you should have an attorney, right? Now, that doesn't mean that you pay someone every month just to sit around and not answer your questions. What it means is that when something arises, you have someone you can turn to. You have someone you can work with. And so when you're finding that lawyer, a couple things to keep in mind. But the number one thing that I would look for is someone who is able to communicate with you and understands the challenges that you face as a creator. You want someone who understands contracts, of course, most lawyers do, but you also want someone who understands copyright and rights of publicity and privacy. Maybe, though, more important than everything else is you want someone who's going to be able to provide solutions and someone who's going to be able to help you understand what's going on. A lawyer who just does everything and doesn't explain what's going on in the process, that won't leave you in a better position. You should learn and take an active role in the representation that your lawyer is going to give you. So communication and involving you in the process, I think those are the things that are most important when you're finding an attorney. Thank you all so much for watching this first episode of Focus on the Law. We have a lot coming in the future. We have a lot going on at the ASMP Academy. And I think you're going to start seeing guests and new instructors and new courses. The roadmap is really strong. The classes coming down the pipeline are really engaging and entertaining. Always come check us out, academy.asmp.org. If you have any questions, shoot us an email, academy@asmp.org. I will see you next time.